All right, it's 9 o'clock. We're going to go ahead and call the meeting to order.
Morning, Jim.
For those in the audience, if you need an agenda, you can get it on the back bookshelf. If you didn't have one already, you're welcome to go get one. And it was pointed out to me last planning and zoning meeting that if you're here for the last one, if you've left a coffee mug, we've set it on the back bookshelf too. So there's some loaf and jug coffee mug that somebody left. So I was told to let you guys know if it happens to be yours. Approval of the December 17th minutes. Does everyone have a chance to review them? Is there any errors? And if there was no errors found, I would entertain a motion to approve.
I so move for approval.
Second.
Motion and second. All in favor signify by saying aye.
Aye.
All opposed, no. Motion carries. Approval of today's agenda. If there's no changes to that, I'd entertain a motion for approval.
I move approval.
Second.
Motion and second. All in favor signify by saying aye.
Aye.
All opposed, no. Motion carries. Consent agenda. PJ, take it away.
Good morning, PJ, Planning Department Director. Consent agenda. The following items have been placed on the consent agenda for action to be taken on all items in accordance with staff's recommendation by a single vote. Any item may be removed from the consent agenda by any planning commissioner, staff member, or audience member for separate consideration. The findings of the Planning Commission are recommendations to the Pennington County Board of Commissioners, who will make the final decisions. Item 3, conditional use permit review, 1003 for Michael Howe to review a dog and cat boarding kennel in a limited agriculture district. Staff recommends approval of the extension of conditional use permit 1003 with 11 conditions. Item 4, conditional use permit review 1730 for Daniel Johnson, Highmark Properties LLC, to review a multifamily residence to be used as a vacation home rental in a general agriculture district. Staff recommends staff recommends to continue the review of conditional use permit 1730 to the February 11th, 2019 Planning Commission meeting with one condition. Item 5, layout plat 1738 for Dorothy Johnson Estates, Great Western Bank of the personal representative for Dorothy Johnson Estates to create lots A, B, C, and D of Johnson Estates subdivision. Staff recommends to continue layout plat 1738 to the February 11th, 2019 Planning Commission meeting with one condition. Item 6, rezone 1710 and comprehensive plan amendment 1709 for Dorothy Johnson Estates, Great Western Bank, the personal representative for the Dorothy Johnson Estates, to rezone 21.39 acres from limited agriculture district to suburban residential district, and to amend the Pennington County Comprehensive Plan to change the future land use from PUD sensitive to suburban residential district. Staff recommends to continue the review of RZ 1710 and comprehensive plan amendment 1709 to the February 11th, 2019 Planning Commission meeting with one condition. Item 7, construction permit review 1801 for RCS Construction Incorporated to review the installation of a 33-inch trunk sanitary sewer line from Southside Drive north along Reservoir Road. Staff recommends to continue the review of construction permit 1801 to the May 28th, 2019 Planning Commission meeting. Item 8, road naming for Shriner Investments. Shane Shriner is the applicant to name a proposed 40-foot wide access easement providing access to the property located in Section 32, Township 1 South, Range 6 East, Black Hills Meridian, Pennington County, South Dakota, to Rockets Court. Staff recommends approval of road naming of Rockets Court. Item 9, road naming for Shriner Investment. Shane Shriner is the applicant to name a proposed 40-foot wide access easement providing access to the property located in Section 32, Township 1 South, Range 6 East, Black Hills Meridian, Pennington County, South Dakota, to Warriors Drive. Staff recommends approval of road naming of Warriors Drive. Item 10, road naming for Shriner's Investment. Shane Shriner as the applicant to name a proposed 40-foot wide access easement providing access to the property located in Section 32, Township 1 South, Range 6 East, Black Hills Meridian, Pennington County, South Dakota, to Jazz Drive. Item 11, road naming Shriner Investments. Shane Shriner is the applicant to name a proposed 40-foot wide access easement providing access to the property located in Section 32, Township 1 South, Range 6 East, Black Hills Meridian, Pennington County, South Dakota, to Bulls Court. Staff recommends approval of road naming to Bulls Court. Item 12, Major Plan Unit Development Amendment Review, 1704 for Kelly Development. Ryan Kelly is the applicant to review the existing plan unit development in accordance with Section 213 of the Pennington County Zoning Ordinance. Staff recommends approval of the extension of Major Plan Unit Development Amendment 1704 with 21 conditions. Item 13, minor Plan Unit Development Amendment Review 1712 for Jeremy Cummings to review a gunsmithing business and a plan unit development in accordance with Section 213 of the Pennington County zoning ordinance. Staff recommends to continue the review of minor plan unit development amendment 1712 to the February 11th, 2019 Planning Commission meeting with the applicant's concurrence. Item 14, conditional use permit 1846 for Brady and Liana Wolf to allow an existing structure to be used as a guest house on the subject property in the low-density residential district. Staff recommends approval of conditional use permit 1846 with 11 conditions. Item 15, conditional use permit 1847 for Kevin and Crystal McKinstry to allow a secondary structure to be used as living quarters prior to a primary residence in the suburban residential district. Staff recommends approval of conditional use permit 1847 with 9 conditions. And the last one, item 16, conditional use permit 1848 for Robert Pace to allow a pole barn as a primary structure on the subject property in a general agriculture district. Staff recommends approval of conditional use permit 1848 with 12 conditions.
Any members of staff want to pull any of those items?
No, sir.
Any members of the board?
Mr. Chair,
Yes.
I'd like to pull number 12, please.
Item number 12. Any other items? Any members of the audience like to remove any of the items off of the consent agenda so they can be heard and considered separately for a separate vote? If you do, come forward, state your name, and let us know which item, sir.
Good morning, Andrew Busty, and like to pull the rezoning of the Shriner Investments.
Which number is that one?
I'm looking for it.
Number 6. Oh, no, that's not Shriner, sorry. It's Dorothy Johnson.
Shriner, the road naming one?
Yes, number 10.
Because there's like 8 through 11.
Road naming, no, we're not concerned about the road naming, we're concerned about the rezoning.
I believe that those are not in the consent.
Say again, Rich, I didn't hear you.
Yeah, I think that's number 19 on the regular agenda.
Yeah.
This one right here.
Sorry.
Andrew.
Yeah.
Oh, okay, number 19.
That's subregs. And then 20 is the Shriners rezone.
Okay. Fair enough, thanks.
Thanks. We'll try again shortly.
All right, fair enough.
So you won't have to.
Any other audience members like to pull anything off of the consent agenda, which is item number 3 through 16 for separate consideration?
Morning.
Good morning.
My name is Michael Howe. I own Keep Wagon Ranch, which is the boarding kennel for number 3.
Okay,
On the amendment, or the CPU, number 2, that the boarding and dog cats not to exceed a maximum of 30 animals. I have 20 kennels, and there's a lot of people that have 2 dogs or even more. So we would like to be able to up that to 40, 45.
something you'd like us to take it off so we can hear that, so you can discuss that with all of us.
Yes.
Okay, we'll go ahead and remove item number 3.
And possibly number 1, I would like to talk to you about just a dog and cat boarding kennel only, where the Pennington County also says
Sir?
that any pet store defined as a kennel, household or domestic animals.
Give us just one moment. Let us get through the consent agenda items, and then we'll talk about specifics on that particular item.
Okay,
Okay?
all right, thank you.
All right, thanks. Any other individuals like to remove any items 3 through 16 off of the consent agenda so that we can vote on those in one single vote, and then we'll address the other items separately? If I am seeing correctly, there's no one else. So that would be items 4 for the consent agenda. That will be items 4 through 11, and then 13 through 16. If that is correct, I'd entertain a motion to approve the consent agenda for 4 through 11 and then 13 through 16.
So moved.
I'll second.
Motion and second. All in favor signify by saying aye.
Aye.
Aye. All opposed, no. Motion carries. Item number 3.
Item number 3 is conditional use permit 1003 to review a dog cat boarding kennel in limited agriculture district. The applicant is Gwen Zeffler and Brandon Zeffler and Travis Dickinson. The owners are Mike and Stacy Howe. This has come before you because of new owners. The conditions have been in place since 2010.
Okay. So the conditions have been in place since 2010. All right, sir, go ahead and give us your name and let us know what you have concerns with.
My name is Michael Howe. And just on the two that I was mentioning before, is one, the conditional use permit be limited to dogs and cat boarding kennel only. Believe it or not, I have a lady that came from Deadwood, works for the Deadwood Mountain Grand, has Lavender Pearl, which is a pig. She checked the facility out. We had not boarded her, but would like to be able to board her if she would like.
It was what?
Excuse me?
What was it?
It's a pig.
A pig.
Lavender
pig.
Pearl pig.
I
She
see.
has her own Instagram page and lives up in Deadwood. The
I
lady
believe it,
works,
actually.
works for Deadwood Mountain Grand. Actually, the pig actually meets more stars than we do. You know, brings her to the office every day, I guess. So she just did a visit and checked the facility out, and we got to meet Lavender Pearl.
So what you're asking is you want to be able to board more than dogs and cats?
Just on those occasions, yes. Because of also what I saw is Pennington County definition of a kennel is any pet store or any lot or premises or portion thereof 4 or more dogs, cats, or rabbits or other household domestic animals, 6 months or old. That's a definition of a kennel, is one of the,
Household domestic.
Any questions? Any questions for Mr. Michael?
The pig is domestic?
yes.
I
Oh,
see.
some pigs are considered domesticated,
I see.
like potbellies and things of that nature. Go ahead, Kathy.
So just to be clear, so you are requesting that rather than specify dogs and cats, we use the definition of the kennel that you read that's in Pennington County code somewhere? Is that
Yes.
right?
Yes.
Okay.
PJ.
Commissioners, if you look on page 5 of 7 under the analysis under B4, the applicant was made aware that any changes to the conditions would require approval from the Humane Society and also re-advertising of the conditional use permit because you're increasing now what has been permitted. Also, condition number 10 of the recommended conditions also states to this fact. So we're not objecting to the applicant requesting this, it just requires more steps. So we'd recommend that this item be continued until the time that the applicant can get approval or recommendation from the Humane Society for his request.
The Humane Society is in charge of how many animals or just the type of
A
animals?
little bit of both. We
I
kind of
see.
work hand in hand there under contract from the Sheriff's Department. That's
Okay.
how they get paid to help assist us.
Will he be, PJ, will he be able to continue to operate currently as
That's why the
he?
conditions are there as is.
Okay, so they're as is, but to do that, if he can go to the Humane Society and get the approval and then, of course, re-advertise for the increase, then,
Yeah, I totally understand that.
okay. Any questions for either staff or Mr. Michael? All right, and staff recommended that we continue this to,
Maybe first meeting in March, not sure how long it's going to take Humane Society.
okay,
Chairman.
is that the 4th of March? That's not the 4th of March, that would be the
March 11th.
March 11th. Continue to March 11th.
That be okay?
Staff recommends approval, continuation till March 11th for conditional use permit 1003 with the following 11 conditions. Is there a motion for that?
So moved.
A second.
Motion and second. All in favor signify by saying aye.
Point
Oh,
of
Kat,
order.
go ahead. I'm sorry.
Just, I was trying to get your attention.
I'm sorry. Go ahead.
That's
Deb?
okay. Mr. Howe, just so you know that any conditions you want to change, then you just come back with the change in the Humane Society, how many animals you want. You just work with PJ and his staff,
Okay.
and then they put it back on the agenda, just so you know that any conditions that you want to change, that's the time to do it.
Okay.
And any exceptions you want from that, then you have to, if they're not working, then you come to us again and say, okay, this is what I'd like to have.
Okay.
Okay?
Thank you.
Thank you, Mr. Howe.
So you would be in the main.
Thank you very much. Sorry, Deb, I didn't see
No,
you down
you're-
there. See,
you're
you
okay.
moved and I'm like,
Thank
All
you.
right.
Thank you, Chair.
we did have a motion. Did we have a second?
I think I seconded.
Kathy seconded. Any further discussion then? Seeing none, all in favor signify by saying aye.
Aye.
All opposed, no. Motion carries. Takes us to item number 12.
Yeah, and I asked to pull that just because I have a couple of questions I'd like to raise. And let PJ finish here.
Yes, ma'am.
On item 12, I was a little curious about conditions 12 and 19. Let's start at 19. I was under the impression, based on some conversations, that we did not have the authority to be concerned with access of water or not access. I mean, we couldn't say to owners, you can't drill a well, or specify that you have to drill a well. And so I was really curious to see that in this is a condition about no private wells. And likewise, on condition 12, I was under the impression that, that the homeowners associations operated completely independent of these, of these, of our rulings. And so, and yet in here, it specifically says they need to be part of the homeowner. So I'm just curious how these conditions came about, and, do we really have the authority to, tell them about what wells they can drill or not?
They came about through many public hearings on this with the applicant present and the surrounding neighbors present. Those conditions are in there at the neighbor's request and also concurrence of the applicant, Ryan Kelly, to have them in there.
Okay.
So it was the,
Many public hearings. We've had many of
I'm
them.
trying to think of the word here. That was the compromise to get it to go forward.
Uh-huh.
It was continued and continued and I mean, it was heard and heard and heard, continued. And that helped with the compromise between the subdivision of the property into 4 lots and the surrounding landowners, their concern.
So then, in a future situation, for example, when I'm asked if there can be conditions regarding using groundwater, drilling wells, and I was always saying no, because we don't operate in that space. So that's not quite right, because in certain circumstances, there are conditions placed on these where you worry about groundwater.
Yeah, I don't know the legality side of it. That might be better answered from someone else, but yeah, these were specifically put in there at request.
I see, okay. All
It's a
right.
request of both parties?
Request of the landowners first and then agreeance by the applicant in time.
And there's a water system out there currently, is that correct? That they can connect to whoever
Yep.
gets those lots? Okay.
All right, thank you.
Go ahead, Deb.
Chairman, I'm with Kathy. I don't know if you can legally tell someone no private wells it's their property. And I don't know if I would put in homeowners association even if an applicant wanted it in there. Because we legally do not recognize homeowners associations, so I agree that maybe number 12 is irrelevant, and number 19 legally, I'd like to know if you can do that. So I don't know if we need to continue it to find those answers, but number 12 I would take out, and number 19, PJ legally, they might have to get private wells later if they don't have enough water source or something, so then we just put it in there and they have to come back for just a well. So just some discussion.
Go ahead, Jim.
Was the private well prohibition a concern about the supply of water, that would be available in the presence of all these, say everybody went in and dug a private well, would we then compromise the community water system? Was that the motive, or what was the motive? Or do you
That was
remember?
the concern. Also, that there is a system out there that the applicant needed to become part of and connect to. And these actually came up not necessarily in the PUD process, but through the plating process as well. So they're in there.
And the
They're in there
developer
too.
agreed to this, and.
I'm sorry?
The developer agreed to this,
did.
presumably, yeah. And people who buy these lots will then be aware of this condition.
Hope so.
Hope so.
And I haven't seen the plat for some time, but I believe that there's a note on the plat to the well, about the wells. I'm not sure. It's been a couple of years.
And,
ahead, Kathy.
I don't know any, I really don't, I'm not at all knowledgeable on the legal part of this, but it seems to me that putting it on a plat, would be a reasonable thing to do. But I question whether it should be in these conditions, and I don't know what to do about it, Deb, if we should continue it, and if we need to clean it up, we need to, or not. I really don't know about that, but it just strikes me that it's
So
a bit out of the ordinary.
I guess I would strike number 12 and number 19, PJ, how many times have we done this before where we put no private wells because of water sources?
There hasn't been one as contentious as this one that the Board of Commissioners decided to put it in.
Okay, we do have Miss Michelle Hoffman, our state's attorney lady.
Michelle Hoffman, State's Attorney's Office. I have not had an opportunity to review this particular issue, but kind of jumps to my mind is that perhaps there were certain concerns under our subdivision regulations, which of course I have not had an opportunity to review in this context, that may have weighed against granting the application for subdivision plating. And perhaps this agreement between the homeowners and Mr. Kelly addressed some of those current concerns, which then persuaded the commission, the board ultimately, to grant the subdivision. I don't know. I think that's something to keep in mind, that this compromise, even though perhaps legally we don't have the authority to order it, perhaps this was a compromise to address other concerns with regard to approving the plat. So I think it's entirely up to this commission whether they want to continue this matter to, for legal to perhaps take a look at these issues.
So is the applicant here today?
I don't believe so.
I don't see him.
Maybe because it was on consent too, so that had something to do with it.
All right. Any further questions? Or do you have more to offer there, Deb?
No, I think I'm okay.
I'm in agreement with you. I don't know. I think it'd be good to continue just to get clarification, at least on 19, because I don't want to get us in trouble if that's the case.
That'd be my motion.
If you'd like to.
On number
you'd
12.
Make a motion to continue item number, continue the extension of the major PUD amendment 1704 with the following 21 conditions to the March 11th meeting,
Whatever is best, so.
at least for now, to the March 11th meeting, and then if it needs further continuance, we can look at it then based on legal.
Do we need it that far out, though? I mean,
Is
just by
that the
looking
next
at it?
meeting?
No, we have one, well, we
When's
have
the next
one
meeting?
later this month, and then two in February.
February 11th.
January 28th and February 11th.
Yeah.
February
What
11th.
was I thinking so far out?
How about February 11th, Travis?
That
please?
sounds great. I don't know why I was thinking so far out. I was skipping an entire month.
We'd request March 11th.
Or something beyond 2 weeks. We have a lot on our plate, so a few extra weeks would be helpful to legal.
Okay,
Okay.
so the second meeting in February, would that be good? That will be the 25th,
25th, February 25th.
February 25th?
Okay.
Okay,
Is there a second for that?
we were just verifying the date. So it's going to be continued to February 25th meeting. Is there a second?
That's what she's asked not to have happen.
No, she said she wanted more than a
enough
couple
out.
weeks.
Oh, I see, February, yeah, now I skipped a month.
See, we're both skipping months there.
It's contagious.
So is there a second for that motion?
I will second that.
Motion and second. All in favor signify by saying aye.
Aye.
Aye. All opposed, no. Motion carries. That takes us to.
Thank you.
Thank you. That takes us to item number 17.
Good morning, Christina Proetti, Planner One. All right, item 17 is layout plat PL 1848 to combine two lots to create Lot A of Layton subdivision. The existing lots are currently zoned as low-density residential, with a combined total of the two lots being 14.19 acres. Currently, there is one single-family residence, one detached garage, one barn, one lean-to, and one shop located on the property. And the proposed lot has an existing approach off of Schroeder Road. There is the special flood hazard area on the property is not studied, so there are no concerns with that right now. The application or the applicant, excuse me, has applied for a layout plat to consolidate 2 existing lots into 1 lot to create Lot A of Layton subdivision. And there are really no other items of concern for this property, since staff is recommending approval with 6 conditions.
Any questions for staff? Seeing none. Any members of the audience like to speak on behalf of this item? All right, current recommendation is approval of layout plat 1849 with the following 6 conditions. Is there a motion?
Move to approve PL 18-49 with 6 conditions.
Second.
Motion and second. All in favor signify by saying aye.
Aye.
All opposed, no. Motion carries. Item number 18.
1 second, sir. Okay. Item 18 is rezone 1810 and comprehensive plan amendment 1809 to create 10 acres from general agriculture district, to rezone 10 acres from general agriculture district to limited agriculture district and to amend the Pennington County Comprehensive Plan, future land use from plan unit development sensitive to limited agriculture district. The applicants are Rustler Ranch LLC and the agent surveyor is Davis Engineering. On January 8, 2015, the applicant applied for the plating process to create a 10-acre lot named Tract A of Rustler Ranch. On February 17, 2015, the Board of Commissioners approved that layout plat, which is number 1501. Ultimately, the applicant had some or too many difficulties to overcome and then wanted to reconfigure how the subdivision of the lot was to occur. So on September 18, 2018, the Board of Commissioners approved preliminary plat 1826 with the changes and subdivision regulation variance 1806, ultimately with 11 conditions. On July 27, 2018, per one of the conditions of the plating process, the applicant applied for lot size variance 1811 to allow a 10-acre lot in general agriculture zoning district. The Board of Adjustment denied this lot size variance, which left the applicant the option, or the only other option, of rezoning the property to bring it into compliance prior to subdivision. Currently on the property, again, the whole thing is zoned general agriculture district, 69.82 acres. There's no special flood hazard area on the subject property. Access is currently off of Newton Fork Road. And there's several buildings on the subject property. There have been several conditional use permits that are temporary for Raleigh Rentals, which began in 2000, and the last one was 2005. All of those have been ended as they were temporary. The applicant is also applying for Comprehensive Plan Amendment 1809 to amend the Pennington County Comprehensive Plan to change the future land use from plan unit development sensitive to limited agriculture district. If you look on the screen, this is the current zoning, and the entire property is outlined in orange. Roughly, again, this is really rough. The applicant is looking to rezone around here, again, really rough, about 10 acres. Then the lot size variance was denied to keep it general agriculture. So the future land use shows the subject property is plan unit development sensitive, surrounded by public lands, which is roughly over 1,200 acres of Forest Service land. The closest limited ag that we have is to a property abutting to the east. So there is limited agriculture in the area. There's also a forest road that runs through the property. This was put in place by the Forest Service in 1966. And the applicant has been working with members of the Forest Service to basically get rid of that, Forest Service subdivision of the property. There's also a 2-page letter from Rodney Brown from previous requests from this applicant that's contained in the staff report, kind of explaining the process. It's just taking them a little while to do it. This was routed through the interdepartmental review. No items of concern came back. With the denial of lot size variance 1811, this is the applicant's only other option to subdivide the property and to keep the plating process move forward. Staff would recommend approval of rezone 1810 and comprehensive plan amendment 1809.
Any questions for staff? Go ahead, Deb.
So, PJ, Why was it planned unit development sensitive? Why was that put on there? Because of the floodway or the
No, there's no
floodplain?
flood on the property. That
Okay.
was done comp plan 15 years ago. There's a lot of the county that is plan unit development sensitive. There's no definition of PUD sensitive because PUD can be mostly large subdivisions.
Right.
It's not going forward with our comprehensive plan, it's not one of the zoning
So
districts that we're
there's-
recommending to keep.
So there's no environmental issues or anything like that that would, there's a reason why someone put sensitive, so I was just wondering if you knew if it was some kind of environmental thing or flood or,
We
Nothing.
can't, we've looked, we can't find
Find
anything
anything?
about it. Yep.
okay, thank you.
Well, sensitive to what?
That's the question.
Oh, I see.
Funny.
I see.
Sensitive to not being other zoning districts, commercial, industrial, maybe, I don't know, highway service, I don't know.
Any other questions for staff? PJ,
Sir?
as I read through this, one of the things I noticed, that the septic permit was pulled, so there's no septic operating on that property at all. Is that what I understand?
Was pulled, I'm sorry, could you?
Well, I'm just wondering, what does it mean by pulled? Does it mean it's pulled like they can't
Oh,
operate it, or is it
requested.
pulled for review?
Requested,
Okay,
yep.
okay. I just want to make sure, because I was like, does it mean it's gone or what?
No.
All right, I don't think I have any other questions. Anybody else have any other questions? All right, seeing none, current recommendation is to approve rezone 1810 and comprehensive plan amendment 1809. Is there a motion to that
Yeah,
effect?
I'll move approval of the rezone 1810 and comprehensive plan amendment 1809.
Motion, is there a second?
I'll second that.
Motion second, all in favor signify by saying aye.
Aye.
Aye, all opposed, no. Motion carries.
Thank you.
Takes us to item number 19.
Good morning, Cassie Bolstead, Assistant Planning Director. The next two items, item 19 and item 20, are both regarding the same property. Item 19 is subdivision regulations variance 1815. This is a request to waive plating requirements to create lots 1 through 8 of the Keystone Y subdivision. The applicant is Shriner Investments, or Shane Shriner, and the surveyor is Spurlet Consulting. You've seen these layout plats before. As this property exists today, it's 4 separate lots. They're all mining claims. They're all currently zoned general agriculture district. There's no special flood hazard area on any of these properties. What they're proposing to do is subdivide these properties into 8 lots. It'd be lot 1 through 8 of the Keystone Y subdivision. All of those lots are 3 or more acres. The biggest one is a little over 5.5 acres. This request for the subdivision regulations was routed through the interdepartmental review process. Nothing of significant concern came back. These guys got approval of a layout plat in June of 2018, approval of a preliminary plat to create lots 1 through 8 of the Keystone Y subdivision in November of 2018. So what they're asking for with this request is they are asking for several waivers. And the waivers, if approved, would satisfy condition number 5 of the preliminary plat that was approved in November. So what they are requesting to waive is they are requesting to allow the use of a 40-foot wide easement in lieu of a 66-foot wide right-of-way. To allow maximum grade of a road to be 15% for approximately 900 feet, to allow an exception to not install guardrail on slopes with a slope greater than 4:1, to allow the angle between road intersections, to be less than 75 degrees and allow a tangent between intersections to be less than 100 feet, to allow vertical curves to be less than 100 feet, and to not perform percolation tests and provide soil profile hole information before platting. All of the requests that they're making come from during the preliminary plat process. The highway department had commented that they needed to reconfigure the road to meet all of those standards, or they needed to request a subdivision regulations variance. They have reconfigured this road before between the layout plat process and the preliminary plat, and this is the best that they can do for this road with the topography that's up there. I'll show you some pictures. This is the Forest Service road going in, but once you turn the corner and start going into these properties that they're wanting to plat, the topography gets pretty steep. So the way that they're requesting to build this road with these waivers, if possible, they just don't believe that they can get a road that would actually meet our subdivision regulations.
All right, any questions for Cassie?
Mr.
I
Chair,
have a question.
Go ahead, Rich.
go ahead, sir.
Well,
right, go ahead,
I was
Jim.
just curious, how many people are gonna live up here? How many lots?
They're proposing 8.
8, okay, so they're, how big are the lots?
Most six out of 8 of them are 3 to 3.5 acres. One of them is 4.2 and one's 5.7.
Okay. So eight homes presumably
Right.
in time. I just don't want to see a situation where you have a treacherous road and too much traffic, particularly traffic, passing traffic and so forth, particularly in times of inclement weather and so forth. So I guess that would be my concern. It's hard to, I guess, for me to make a judgment as to whether 8 homes up there is too much traffic or too little, but, and I can't quite, these roads look to me primitive at best. Even once improved, they might be at times treacherous, but I guess I'm needing some direction here. Either from you or somebody who's a road expert,
Right.
Are there
Hold on,
homes?
Sandy. Rich had a question.
Oh, I'm sorry.
Go ahead, Rich.
I tend to agree with what you're saying. I don't know if I can be in favor of granting maximum grade variances and then saying at the same time, oh, by the way, we don't need guardrail at the bottom of a 1,000-foot run of 15% grade. There's not a whole lot of 15% grade roads in town. I can think of some that are right off of Sheridan Lake Road, and those types of roads are some of the first to get plowed during the year in inclement weather. And I don't know if granting the guardrail exception in addition to granting the maximum grade variance is a safe thing to do.
Sandy, did you have a question?
I just wondered, are there homes there now?
No. Nope, all these
No
lots are
homes.
vacant right now. There's nothing up there right
All
now.
right, thank you.
Cassie, has anyone talked to the highway department to see what their thought is on these variances?
Yes, this was routed to the highway department, these variances. During the preliminary plat, like I said, the highway department had all those concerns for what they're requesting to waive right now. The highway department's comments on these subdivision regulations variances is the roads in this development serve only the development and are therefore classified as local roads. Pennington County subdivision regulations define the requirements for local roads and not the American Association of State Highway and Transportation Officials, a policy on geometric design of highways and streets. AASHTO is referenced in the subdivision regulations for minor and major arterials only and is not applicable in this development. So they the first time they had lots of concerns and this time they're,
And they kind of
saying that those standards don't apply because it's a local road.
gotcha.
So there are no standards?
Local roads in our subdivision regulations are pretty lax in terms of how you have to develop a local road and what standards you have to develop them to, because they're not meant to be highly trafficked areas.
Any further questions for staff?
Mr. Chair.
Go ahead, Kathy. Oh, I'll let Kathy and then I'll get to you, Sonny.
You know, I appreciate the situation out there, and the topography and such just doesn't lend itself to meeting all the requirements necessarily. But even now, if we consider them local roads, those requirements kind of go away. But I think, and I'm not worried about inclement weather because they're going to be plowing their own roads. If they think there's a problem, well, then they're going to have to deal with it. But, I'm surprised that the fire administrator had no comments, because to me, that's the issue. If there is a fire, and because of these roads, can a fast-moving fire truck that's on a mission to respond, are these roads going to give them pause? And so as I said, I was a little surprised that the fire administrator doesn't have a comment on it. And so it seems to me that if they don't have a comment, then we should approve this.
Sonny?
These images that you're showing us
Are these just up to lot 1, or do they go beyond that?
These are up to about these go up to about the start of lot 3 of what they're wanting to plat. The road, I was up here in the summertime and I didn't really feel comfortable going any further than that. So this is a really primitive road right now. This is not developed to how they would. It's just basically as you can see, a 2-track trail. So until they develop it further, I only went to about the start of lot 3.
Okay. And on the guardrail issue, is there a reason why they wanted to eliminate that or remove that?
They provided a description for what they were requesting. In terms of the guardrails, let me see if I can find it again. Their reason for the request, as stated in their submittal, was the roads within the Y subdivision will service only 8 residential properties with no through traffic. Due to the minimal amount of traffic that would circulate through the subdivision, it is felt that full developed road requirements are not necessary. Additionally, looking at other gravel roads in the Black Hills, a majority of them have no guardrail installed, even when steep slopes are present, and they attached a typical Black Hills Forest Road that is a through road to the public with no guardrail installed.
Okay,
That's
thank you.
their request.
All right, any further questions for staff? Go ahead, Deb.
Chairman, I believe what Rich is saying with the 15% grade, there isn't that many in maybe Rapid City, but Pennington County, I think that's a good place to start now, is to maybe put some guardrails on some of these safety factors if it's pretty high grades. I think the safety of that road, since a lot of times they're gonna come back with requirements to make it smaller, and a lot of times make it not, you know what I mean, not as wide. I'm gonna guess that's gonna happen. So, I agree with Rich on the safety factor with putting guardrails on that 15% grade areas. Not the whole thing, just areas where there's safety factors. So, I don't know how, we had, what number, if we did that, Cassie, are we changing? Can you
No,
tell?
you guys do have that option. You can waive some or all of their requests and deny some or all of their requests. You guys have that availability to do that.
So, Ms. Cassie, what number is the 50% grade, is fine, but for me anyway. And then how do we make it so they have to put the guardrails on that 15, not the whole thing, but the 15% grade areas?
Basically, what you would be doing, the way you're proposing it, Commissioner Hadcock, would be to approve the requested variances 1, 2, 4, 5, and 6, and to deny number 3. Number 3 is the one that allows them to not install guardrails. So if you denied that one, they would have to install guardrails.
Okay.
But may I?
Go ahead, Kathy.
But I think that it's going to take a little more than that, because the way number 3 is, and the way that, I'm assuming it's how the guardrail requirement is that when the slope, the road goes this way and the slope of the hill comes this way, and you put a guardrail where it doesn't have anything to do with the grade of the road, the 15%.
It has to do with slope.
It has to do with the slope of the hill coming down. And so if the intention is to require a guardrail when, one, there's a slope greater than 4-1 coming down the hill,
Right.
and the grade of the road is 15%, then that needs to be, we need to amend condition 3 to specify that.
Can you do that, Cassie?
Jim, you have something?
It seems to me that the developers really made no concession on these road elements here. And the fact that you narrow the road really does complicate things. I mean, if the road is wider, there's more room for air, it seems to me. And so if they're not willing to widen the road, then it seems to me some gesture of safety should be made in the way of guardrails. Although my experience in seeing guardrails in roads like this in the hills is I don't know if the guardrails would do much good. They seem to be, you know, they're not in concrete, they're just driven into the ground, and a heavy vehicle would easily probably penetrate them and go off. But anyway, I'm always in favor of allowing people to make developments in circumstances that might not be obvious to begin with. But ultimately, it seems to me we ought to have some standards. And here we're kind of just, throwing the baby to the wind here. I don't like that. And I would like to see some kind of specific, improvement in these road conditions. I just think that's the fair. I know it's going to increase the price of the property marginally, but
Yeah.
I think it's important.
But just to be clear,
Go ahead, Kathy.
what they're requesting is a narrowing of the easement. A 40-foot easement versus a 66-foot
Yeah.
right-of-way easement. It really doesn't address the width of the road.
How wide is the road going to be?
I don't know how wide they're proposing for the road to be. Generally, within a 66-foot wide right-of-way, generally it's 24 feet wide driving surface. I don't know how wide they're proposing
My
this road
guess
to
if the
be.
easement's narrower, the road will probably be narrower too, won't it?
Yes. In the 40-foot wide easements, a lot of times what we see is like 15 to 18 feet wide roads.
And we've had this before with the the county highway department saying, and I'm not faulting them, but I think it's unfortunate we don't have some standards that we can work with, because it makes this difficult for us. It makes it difficult for the developer too, quite frankly. But anyway,
So, Chairman,
Yes, go ahead,
I
Deb.
guess the bottom line is until you figure out what they're doing with the road, the width and everything else, it's hard to make standards for a road. Even 4-to-1 slopes, it's hard to make standards because, like you said, if it's wider, you have more room for error. So without knowing what the road is, it's kind of hard to say rails or no rails at this point with the 4-to-1 grade or 15% or whatever you're saying, 4-to-1 slope, 15% grade.
Right. I do believe there's a couple of people who would like to speak on this. They might be able to answer that question.
Okay.
Mr. Chair, can I just point out, I just read this in one of their requests, that they propose the access road will consist of a 24-foot wide gravel section with 2 feet of shoulder on either side. 6 feet of easement will remain on either side of the road surface if future improvements are necessary. Just to throw that out there, that's in their submittal stuff.
Where was that at?
It's in the stuff that they submitted for the variance request, the page right after the last page of our staff report in number 1.
Oh,
Encroachments.
gotcha.
Request.
Any further questions before I open it up to public?
Open it up to public.
Okay. Would anybody like to speak on behalf of this item? There's a couple of them, but I'll let this gentleman go first.
Andrew Bussey with Keystone Adventures, and we're the property across the street. And I'm a little confused because we have a rezoning issue, which is the next item on today's agenda, and we also have a request for variance to the regulations for the plat. And so if it's okay with the chair, I'd like to request addressing both issues before the vote on the variance.
Okay. I'll give you some leniency. How does it play in there, if you don't mind?
Well, currently, I kind of feel like we're putting the cart before the horse on the variance for the plat for a subdivision for roads when the current zoning doesn't allow it.
Okay. We'll see what you have to say.
All right, thank you.
Helicopters up there is what he's saying. Helicopters up there is what he's.
Thank you.
So in regards, I'll just start out with who we are. We are the helicopter operator that's across the street from the proposed subdivision and the replatting and the platting variance request. And so that first page there, I just want to identify where we're at in conjunction to those plats. And the land that we currently own all has an H on it, including the heliport. And then we obtained an easement over the hotel this last year, which wasn't depicted. We started this process in 2009 with a different planning and zoning department here in Pennington County. We went through and tried to identify the best place to put the heliport, and that heliport was selected with the help of county officials. And we purchased the property because of its zoning proximity to the Highway 16A corridor and the lack of residential properties in the immediate vicinity of the property. Going forward, just a real brief bit about the importance of the helicopters, which I know some people find to be a nuisance. And we've heard that in the county before. We operated for the first time in 2018 this summer. And I'm glad to say we only had one nuisance complaint, and that was from the other helicopter tour operator. And so I feel like we're making progress. In fact, the neighbors that contended the heliport actually wrote us and told us we were doing a great job. And they wanted us to keep it up because we were pushing helicopters higher and further away. And so trying to make a positive impact on the Black Hills. As far as nuisance and noise abatement, just to remind the Commission Planning Department how important tourism is to the county. We generate close to $3 billion of revenue, half of which is here in Pennington County. And it's extremely important just after this first year of operation how important attractions are. People come to the Black Hills for Mount Rushmore, but they also come here to do fun things. And what we experienced is our season's limited to the end of October, and we've been receiving numerous calls all winter long requesting people to fly. And it's because people need things to do when they come here to visit. And so what I look at is a potential rezoning and a variance to the plat request limits our future and puts our jeopardy in business because that's a subdivision and we have a prior preceding ruling by the Planning Commission in 2011, which I included in the folder, when the competition, we originally looked at that property and then the property owners, after we declined because of the proximity to residential property, the property owners took the land offer and went to our competition and they tried to put a heliport in there in 2011. It was met with fierce opposition from the surrounding property owners and the Planning Commission vetoed that heliport. So that's our precedence that we have in Pennington County. And so what I printed off today was a picture of our zoning map currently. And then,
Can we have those pictures up there, PJ, the zoning map, where his heliport and the residents, the Rustler's Rant's coming in? Where's the proximity? So his heliport is where?
ma'am,
PJ?
Commissioner Hancock, it's immediately across the street to the west.
Can you circle that, PJ, where his heliport is?
It's the red one, right? No. It's the pink one. Oh, that's right.
Looks like, if I read, yeah, right in that red area, right.
Purple.
Thank you.
And just to reiterate, we are a highway service zoned property. That's always been highway service from the time it was transitioned from the Forest Service. And that meets the comprehensive plan for Pennington County, our original comprehensive plan from 2003. Identifies it on the map, which I also printed out, is business and commercial development. There's out of paragraph 6.3, it talks about a commercial corridor, and I would contend that US 16A is probably the carotid artery of our commercial corridor for tourism in the Black Hills.
Sir, how do you feel 8 residential lots are going to impact your business? I'm just confused.
It's a great question, ma'am. So if we look at preceding issues that we've had here in Pennington County in 2011, I understand the chronological argument, which is what the Supreme Court uses to uphold property disturbance disputes. And basically that means the property is, we have the precedence of time. We bought the property in 2014. The rezoning occurred in 2019. However, what it doesn't do is it doesn't eliminate the ability for new homeowners to come in and argue or complain about the noise disturbance. And what we've seen in numerous places throughout the United States is that homeowners come in and build property or build homes on property adjacent to heliports, airports, racetracks, anything that creates noise, and then create a coalition, and that coalition comes and fights against one property owner, and then you, as elected officials, have to weigh out whether it's going to be more important for the group or more important for the business. And the majority of the time, the business loses. And so I see an opportunity for the planning department to come forward and prevent something like that from happening. And I just bring up the 2011 ruling argument because in 2011, we had basically the reverse of what's going on. And I printed off a zoning map for you. We
Sir,
had,
Can I ask you a quick question, though? Is there a fly zone or anything around your heliport? I mean, does it legally, do you have to have a certain amount away from residents or anybody?
so to answer that question, Commissioner, we don't have to have a certain distance from anybody or anything. The United States recognizes navigable airspace at 300 feet for helicopters, except for takeoff and landing. The issue is that property is immediately adjacent to the heliport, so we will be descending below the 300 feet for takeoff and landing. And the other issue is we do that about 700 times a month. And so for people that love helicopters, it's a great place to live. For people that don't like helicopters, that could be a terrible place to live. And the reason why I'm concerned here isn't to try and dissuade the Shriners from building. If it was Shane Shriner who was going to be living next door to me, or Sonny Shriner, I'd be more than happy to have them as neighbors. The issue is we're building a subdivision in order to sell property. And you can say, well, it's the property owner's fault because they didn't know the heliport was there and bought the property. But I'll tell you, I've never had a salesman tell me why I shouldn't buy something. Case in point is when they advertised the land for sale 2 years ago, they excluded the heliport from the photo. And I included that in your guys's.
Interesting.
And so what it does is it makes it difficult as a realtor. Their goal is to sell property. As a business or a land developer, their goal is to sell property. And so nobody's looking out for this, who's buying the property. And then who has to deal with the property issues are the neighbors. And so I think everybody should be able to do what they want to do with their land. However, there's no rules, regulations in place for notification of the heliport. And we operate from May through October, so theoretically, somebody could come in and buy a property in the off-season, never hear the helicopter, never see the helicopter, and then get stuck listening to 700 helicopter flights per month.
Yeah, it makes sense.
I would also contend that that property, because of the grade, if you look to our 2040 vision, which I compliment the staff on, it's really nicely done, is on a ridge line, on rocky surfaces, and essentially is in an amphitheater, which compounds the noise problem. I mean, it's essentially like putting your hand up to your ear. We're just enhancing or increasing the noise disturbance. For us, we love that sound, and for people that are seeing the helicopter coming to them when they're getting rescued or when their house is on fire, they love that sound. But I would venture a guess that the people that can afford to build on this proposed subdivision won't like it.
Unless they're helicopter enthusiasts.
Right, and I've been trying to identify people that want to be helicopter enthusiasts to buy the property in conjunction with me from the Shriners. So we're working on that. You might ask why I didn't buy the property, and it was up for auction. We bid on the property. I bid almost twice past what appraised value was. And then I had a friend pull me aside and tell me who I was bidding against. And once I realized who I was bidding against, I stopped bidding because I didn't want to drive up the property value for the Shriners. And so I pulled out of the auction, and I've been working, trying to figure out a way to find funding to purchase the property to prevent future encroachment. As past, we acquired additional 54 acres just for this purpose alone. And so we've made the investment to try and create as big a buffer zone as possible in this area, and I just need more time to go forward.
So if I look at those pieces of property on that one auction you gave out there, what property, or will all of those pieces be within that 300 foot whenever you're landing?
Well, the issue is it's rising terrain, and so essentially 3 out of the 4, the 3 10-acre or the 3 larger parcels.
Any questions?
I'd like to hear from the applicant.
Okay. Any other questions for?
Mr. Chair?
Yes, go ahead,
I
Kathy.
do have one. I appreciate your concerns because I've seen that happen since I've been here, is property owners that moved in after something had already started, get attention. So you're absolutely right about how this can play out. But here's what I'm questioning. Highway 16A in the summertime is just constant cars. So that is a big noise. And these, even in just looking at the scale on this map, these properties are all, well, one's, 500 feet, the rest of them are within 1,000 feet, or maybe just a tad more if you get up the hill a little bit. And considering it's upslope, I live near here, so I know exactly, where we're talking about. I mean, that is just gonna be noise, noise, noise. And so, I mean, do you really think that it's gonna be the helicopters that's gonna get their attention, or all those cars on 16A?
Ma'am, to address your question, the issue is the helicopter is a single helicopter and it's a single operator. And what I've just seen with my experience doing the research and working in the industry for the last 19 years is that everybody drives a car, and so it's really hard to point a finger at noise created by people driving by when you yourself have one in your garage. And if I could have a community of helicopters right there, I would love it. And so I feel like we are a target for the noise, even though the decibel level is the same as the motorcycles, and the noise from the highway creates a disturbance. They're going to just focus on the helicopter and be my worst enemy. Even though we have the legal argument, I still have to pay to defend myself, and then you as elected officials someday are going to have to make a decision whether you're going to uphold the chronological argument or the argument of future landowners.
Question.
Go ahead, Jim.
Yeah, you're absolutely right. The curse of the common, which is everybody owns a car, and so it's a common sort of circumstance and condition, and it's where the helicopter operator is an individual, and you can go directly to them. But now you're not worried that these people will somehow restrict your current operating? Are you more worried that in the future, as business gets better for you and you can add a couple more helicopters and perhaps another helipad, that's when circumstances become more difficult? Am I right? Or
No,
because I don't agree with you that what would happen here, that there would be pressure from these 8 lot owners to somehow shut your operation down. That doesn't seem like a sensible scenario to me.
I don't think it's sensible either, and I don't think these lots really are for the people that I know from South Dakota. Like, what we're talking about is pretty steep building on pretty rough terrain, and I'll tell you, having built across the street, it wasn't easy, and I anticipate these lots are going to go to people that have significantly higher incomes or had higher incomes than myself, that came from out of state, and where sensibility doesn't necessarily play into rational decision making. And I just feel like currently, if somebody comes in and buys the property and knows the heliport's there, and they're buying the property at a reduced price because of the helicopter vicinity, and they're okay with the noise, I don't think we'll have a single complaint. But the issue I find is that somebody comes in the off season, there's nothing there, there's no traffic, there's no helicopter. They buy the property when it's somewhat peaceful and quiet, and then all of a sudden May rolls around and we're flying 700 flights out of there that month. Now they're going to come back and create a complaint with the county, which I'm going to have to attend to and you're going to have to listen to, complaining about my noise and my nuisance. And so, am I concerned about present?
Yeah, I understand what you're saying, but I find that hard to, I can't imagine, I certainly wouldn't be receptive to that kind of thing, and I don't think most of us would, It's a condition of who's there first,
I agree.
And I'm sorry, you may have come in May and bought, or before the helicopters got going, and I'm sorry you bought your property, tough luck. I mean, a little research would have immediately dispelled the pristine nature of these particular lots. But
I can take you to a case in Keystone that preempted the move from the current operator in Keystone. He was located adjacent to the hotels on the south side of town, where the tramway currently operates. We had a public official who contested that location because of the noise nuisance, even though he built his home after the establishment in 1962 of the helicopter operator.
right.
And Keystone forced the operator to move to a different side of town. And so not to be argumentative, but a case right here in Keystone in South Dakota in the last 10 years, 15 years would be a perfect example of somebody building with had significant political influence that forced the operator to move.
Yeah, well, you may be right about that, and I think you probably are. But my feeling is that it would be very difficult if you were not expanding your operations. But the reality is you will be expanding your operations if for no other reason than more flights. And that will be easily, they will be able to track that, and then they will be able to say that the status quo has changed. So now we can address this helicopter menace across the street. But these helicopters are I'm sorry, they're an insidious presence. Quite frankly, I wish we did not have them at all. And I was on the commission when we frustrated the gentleman down at Custer from moving up on Highway 16 to put in a heliport that was going to be closer and more profitable for him, because for the same reason, there were established, residential areas around there that clearly prevented him from winning the commission's support, and I can see that. But I do know that your situation about Keystone is, although Keystone might be a little bit different situation in terms of the intensity of activity and also the closeness to Mount Rushmore.
Correct. And to address the noise, that's an issue that we've had here in the Black Hills because we haven't had competition. We've had one operator that was able to go and do what he wanted to do, and the regulations, the federal regulations allowed him to do that. Again, with the commission's approval and the help of the planning department, we located a great property and we operate a very sustainable, environmentally friendly business. We don't run 6 helicopters constantly back to back, and we're not flying at 300 feet above the ground over wilderness areas and next to the monument or over Harney Peak or Blackout Peak. We're operating in a sustainable way that we can also respect. Keep in mind, we are the rock climbing guide company out of Keystone as well. And so we have clients on the ground that we try to respect as well. Not to mention Anna, my significant other, is a pilot biologist for the U.S. Fish and Wildlife Service. We have a sincere interest in preserving the Black Hills. And if we continue to do nothing and let one operator go through and operate however he likes, without any regard to people or property on the ground, that's what we have to deal with. Now people have a choice. They can go to the other operator, or they can come to us and experience a fun ride without upsetting everybody that they're flying over.
Chairman?
Thank you, Andrew. I was going to get us back on track here.
Okay.
Do you have a question specifically? Because I'd really like to hear.
Well, my
from
bottom
them.
line is I actually was on the commission when, tell me your first name again?
Andrew, ma'am?
Andrew, was going through this. And it's a lot of people, if they move in that area, they're going to call safety factor. And when they start talking about their kids and living there, guys, it becomes a huge issue. Andrew, how long, I forgot, it was a long time, you've served the National Guard flying helicopters?
20 years in April, ma'am.
Okay, and he's just told you his background, and he's trying to give us forewarning that I understand the noise in one sense, but most of the time when I've been up here, whether it be the hospital when I was on the city council and their helicopter, or this issue, it took a while for Andrew to convince many of us that this was going to be a good thing and a safe helicopter unit to put in that area. So I'm understanding there's property rights, but I'm also understanding he's given us forewarning that that's 700 trips a month. And I don't know how we secure his business, or what's the solution to be able to put a residential area of 8 lots in there. But I'm prone to take the business that was there first, or the property that was there first, whether it's residential, and side with them. The only thing is, he's right. You should have heard the complaints and the people from a long ways away, and it wasn't even his business. So how do we create a area where we can do business as a helicopter port or helipad and still have residential in there. I don't know what that solution is, or if we can put it somewhere when people are buying lots, so they have forewarning. So when they come in, did you know? And then, of course, they never knew. Like
Right.
Andrew said, they'll come in on a time where there's no helicopters flying at that time. So I'd like to protect his business for the future, but I also believe that we got to find some solution with people in the surrounding area that got, they have land to sell. So what is that solution? My bottom line is, how do we put it out there that there's a helipad across the street, and if people are buying lots, PJ, can you put something on a plat or a sign or something so people know that?
That was my thought. Put up a gigantic sign that says, caution, 700 helicopters a month. Well, something that says, warning future
Not a bad
homeowners or builders.
Right.
Not really appropriate for a plat.
Just
No, but you could put up a sign on your property so
Ma'am,
people
we've
know.
worked with the DOT. We have the tourist directional signs. And so what we did was before this property was sold, and once it became, so it came on the market on a private sale in 2015, 2016. As soon as that came out, we immediately moved forward with the Department of Transportation putting up a low-flying aircraft sign on 16A. We put up the tourist directional signs on 16, and then we went ahead and put a billboard on our property to try and help people become aware of it. We went online and placed a digital signature on Google Maps, MapQuest, TripAdvisor, everything we could to help notify the public that the property adjacent to them was going to have a helicopter.
So Andrew, you basically found our solution, and if someone's not getting a clue by that time and still build, this might not be the same planning commission for future or the commission, but I would document all that, so when people did do their complaints, I don't think you can get away with it or get away from it, Andrew, no matter what, because it's property rights. Does that make sense? Because we can't just take a zoning area and make that whole area commercial. I mean, we could if the property owners thought it was a great idea, or highway service.
And I agree wholeheartedly. And the one thing I would ask today is that so we're talking about the variance for the subdivision regulation variance, and we're also talking about item 20, which is the rezoning. And so, number one, from my understanding, reading through our regulations here in Pennington County, is that currently it's only allowed one dwelling unit per acre. And so with the limited acreage there, we're talking about 3 units. What the Shriners are proposing is going to a low-density residential, I believe, on item 20. Correct, low-density residential, and from my understanding, the low-density residential bumps up that potential to 1 dwelling unit per acre.
3.
Per 3?
Per 3.
1 per 3, so then we're talking about 10 units. So we're looking at 3 houses versus 10 houses.
Well, I think that planned unit development sensitive probably comes into play now. So,
And so, number one, we're opposing the rezoning, and we're also opposing the variance, plat variance. And the reason why we're doing that is because we find it inconsistent with surrounding zoning. That map with the zoning on there shows all of the current zoning. And so putting low-density residential in there at this time and point creates a current issue. We also oppose because it's inconsistent with the comprehensive plan we're currently operating on. It's also inconsistent with the 2040 vision that they are putting out, and I think we'll see each other again in a few weeks to hear about that. And we're also opposing because it's inconsistent with prior rulings of the planning and the commissioners in 2011 with the Silver Mountain heliport.
All right. Any further questions for Mr. Andrew?
no, just staff.
Thank you very much. I think we have some questions for staff. Thank you, Andrew.
Thank you, Chair.
Kathy, I believe, wants to ask PJ a question.
PJ? Yes, ma'am. Am I right in thinking and understanding that right now, there's 4 lots, even though they're zoned general ag, there could be 4 houses built, assuming the roads and everything got arranged, in the current setting, current situation.
Correct.
Right, so what we really are considering here is that, do we limit it to 4, or do we increase the density to 8? That's really what we're faced with here. Is that right?
Ultimately, with all the
Ultimately.
different permits, yes.
Right, okay, thank you.
You're welcome.
Any other questions for staff?
Okay, so we're on 18 rezone though, aren't we?
No, we're
19.
We're 19,
I'm sorry, I lost my mind.
19 subregs.
dealing with the road.
Waivers, yep, sorry. So
Mr.
you're
Chair.
right, Kathy. And then the next one is,
Yeah, right.
okay.
But I mean,
apologize.
there's already the current setting is that allows 4 houses. We're in item 20, we're just asked to rezone so that it would allow 8 houses.
Rich, did you say
Mr.
something?
Chair,
Go
yeah,
ahead.
I have a question. We got sheets, we got the cover sheet, and then we got basically the plan and profile sheet starting at 5.1. And I was looking for the typical section to try to understand what the inslopes are around some of these corners and these steep slopes. Does staff know what the inslope, what they designed this at? Are they 3-to-1s, 2-to-1s, 4-to-1s?
I don't know. They had bigger design plans, with their preliminary plat. They had large-scale design plans. I don't remember what those inslopes are, though.
Okay.
Chairman,
Yes, go ahead, Deb.
I think there's more to this, number 19 and number 20 now that we have more information.
I agree.
And myself, I can't vote on it today. I'll just tell you without, checking this out a little bit closer. I don't know if this commission needs that time, but I can always get more time. I can vote no today and have more time when it comes to the commission. But for me, there needs to be more information. Rich had brought some of the stuff with the heliport. I think, almost 19 and 20, I'd make a motion to continue. I know I can't make that motion since I talked, but
Well, I'd at least, if there's others who would like to put some information out there, I'd like to hear what they have to say
would be
for us
good.
to
That'd be good,
continue
sir.
hearing as well.
thank you.
There's a gentleman here. Are both y'all together?
My name is Paul Kraft. I'm with Spurlick Engineering. I'm one of the engineers for this. I can kind of answer all the questions you have about all the plan and profile and everything.
I'm Shane Schreiner.
So you're
Schreiner
Shane and you are?
Paul.
Shane and Paul.
So as to regards with the road itself, we're looking at basically developing it as close as we can to what Pennington County requires for their roads, for local roads. So there'd be a 24-foot wide gravel road section. And then there'd be 2 feet each side for a little buffer. And then from there, we're looking at doing about 1.5 to 1-to-1 cuts on either side. This is kind of typical if you look, actually let's see, over up in this area, there's a Calumet Road. That's kind of the typical road section that I kind of went through. There's 2-to-1 slopes that are natural slopes that they put already through there. If you've seen some of the topography there, the natural topography is about a 2-to-1 slope on there. So to catch up, to get some of these roads to work, because now we have a flat section and everything's tipped way to the side, we need to catch it up. So there'd be a 1-to-1 slope in some of those sections to catch that. As for the 15% grade, in the staff report for the preliminary layout, looking at section 5, number 2, the county went through and said the table 1 limits the maximum grade to 12% throughout the entire road. There is allowance up to 17% for a maximum of 500 feet. One of the roads that we do have is at 15%. Through there, so it's about half of that in-between stage between the 12 and 17. We're just asking to go up to 900 feet. Do also keep in mind with all of these, we've had made provisions to make it so that way ambulance, fire trucks, they do have turnarounds. So at the bottom of this 900 foot section, it does flatten out, so that way there is turnarounds and everything for fire trucks. Same with all the other roads, there are cul-de-sacs, turnarounds, things like that. So emergency vehicles are able to get in and out. And then as for some of the intersections and everything like that, those all come in as flat as we can get them. Like I said, the topography in this is very steep in here, so some of the roads are a little steep. But do keep in mind, Rapid City, for a paved road, their maximum slope is 12%, so we're just asking basically just 3% higher than that, and it is particularly in just one section of road.
All right, any questions for?
One question.
Go ahead, Kathy.
Just to get a sense for me about what this road's gonna be, are you familiar with Trixie Lane? It's just a little ways further down from the Keystone Y.
If I
Hill
probably
City.
drove by it a few times.
Did you ever drive up that road?
I don't think so, no.
Okay, well, it's a pretty tough road. It's very, very steep, and there's
Right.
no guardrails, and it's narrow, and it's a private road, you know, local road. But I was just wondering if there was any, how this road would compare to Trixie Lane, which is,
Let's see, I'm trying to think of some of the steeper roads here in Rapid City.
Would there be the one, right before, Sagdalens did it? It's before the, Rockerville and, where where they were looking at doing this helipad. There's that subdivision up there. I know those are.
Yeah, I can't think of the name of it.
Yeah, I know those are very, steeper inclines as well. And, like I said, what you guys were looking at was something that the previous person did that wasn't, he shouldn't have. So those road paths that you were looking at, the road's not even going there. What we're doing is that they basically took where the water ran and dug that out, but we're going across and over to put our roads in. Like, those are probably, I don't know, 20.
Right.
They're ridiculous.
There is, yeah, there would be 2 full lanes for two-way traffic going through this, so people aren't running around each other. This would be 24 feet wide of road.
And too, with like with these roads, they're, it's just the right of way that that we wanted to shorten up, not the road. Even in a 66 foot, you still would have the same road. It's just you would have more of, and it would be a dedicated right of way, and we want it to be an easement.
And the reason we're asking for the narrower 40-foot is there's no water, there's no utilities that are going in the road. It's just going to be the road itself. There's no sewer, no water. There's no real
Not gonna
room.
be sidewalks.
Yeah.
So Chairman,
Yes, go ahead, Deb.
based on the information, what they're saying, I'm not against what you're doing. I think I just need more time, and I've met with Paul before on issues, and I wasn't against it. What I need to do is, for me, I have to look at what you're saying, and then you show it to me. Because you're, like you just said, you're not putting the road where they just said where the road was gonna be, and some of those might take away some of those safety factors in what we're talking about today. And then,
It is showing on what I've looked at here.
yes, sir, but I'm saying bottom line, it's a lot easier for at least me to picture it and agree with it, knowing all the information,
So what would you need then, I guess?
to meet with you. Paul knows that. I
Oh,
usually.
you mean to like,
I don't know, that's for me, that's not your board, but they would probably, I don't know, it's up to you guys if you needed to look at it and see, so. I still have time, so I can meet with Paul and you guys and the guy, Mr. Andrew from the helipad.
Any further questions for Paul or Shane?
Mr. Chair.
Go ahead, Rich.
So will the subdivision maintain the responsibility for the maintenance and repair of the roads, or will that be dedicated right away and then become county roads?
it won't be dedicated right away, no. It'll be, it'll be maintained through, we haven't actually got that far to go through, like with covenants and like a road, I don't know.
Road district.
Road district. But it won't have, the county won't have anything to do with it.
Okay. So the fill slopes on here are 1.5 to 1s?
Yeah,
Is that right?
It's catching on the downslope, it's a 1-to-1 on some cases, and then going up, cutting through, it's a 1.5 to 1, I believe, catching on some of those.
And has there been geotechnical investigation this material can hold up on a fill slope at 1 to 1?
There has not yet. We just need to verify with the geotech. This is the final design for it. Make sure to verify with them that this is applicable through everything.
These are at the limits of what I would consider, these design criteria. I don't know how you can I look at some of these grades and catching this road at this slope for a certain distance and then having to turn a corner at the bottom and not having guardrail. I'm not sure. I think that I would go for one, but not both. I don't think you can exceed one set of criteria and then not have the safety on the other side of it. So without some sort of concessions from the developers and the designers on some of these safety concerns, and I've redlined a few areas that I think that are specific concerns, and I can go over those if you want. But I won't be in favor of that without some adjustment to item number 3 on page 2 of 9.
Any further questions for Shane or Paul? All right, thank you, gentlemen. Any other members of the audience like to speak on behalf of this item?
Yes, good morning. My name's Lisa Cook, and I'm just a citizen. I'm actually here for a different agenda item. However, I do have something to say about this particular matter with regard to safety and with regard to creating eyesores for the community. The grade, I believe, here is an issue, along with the issue of inclement weather. The photos that you showed us showed that in some places along this road where we had someone testify that even though it was her job to go and review the entire thing, in good weather, she only felt good enough going so far and didn't proceed further because she didn't feel comfortable doing that in really good weather. When trees cast shadow on the road, and in one of the photos we did see that trees were casting shadows on the road, there can be durable ice that is maintained there regardless of what the weather, regardless of whether or not there's been snow. The ice will stay after a snowstorm in those shaded areas and create a hazardous area for driving. I can think of 3 examples just here in town or close to town where the Planning Commission has created similar conditions, and you basically wind up with unsellable lots because of the road into the plot is untenable. One is on the west side across from Canyon Lake, just by Blessed Sacrament Church, where there is a plot. If you look just west of the church, it's way up there, little crow's nest spot. To get there, not only do you have to turn off of a busy road, 44, you have to make a hairpin turn and then make another turn to the left and go up this steep grade to get to the plot up there. That lot has been like that for, I don't know, 5 years or something. It's unsellable. There's another one that is just behind what used to be a little stop and rob type place on the corner there across from Canyon Lake, where there's a lot of red dirt. And you have to turn off there at this little, there's no business there now, but it used to be like a little, convenience store type place and a gas station. And you turn off there and you go up this crazy looking grade there to get up on top, right across from where Linda Lee Viking's office is. And that has created a drainage issue. There's a bunch of red dirt coming down there whenever there's precipitation that drains right into the road. But apparently that was approved by folks as well. There's another place just like this, which must have been approved some decades back. It's on Nemo Road. And I noticed that place is for sale. But before you get out of before you get to turn off where there's a little hiking trail and things just across from, I want to say, Berry Pines or something like that, you can see this house. It's sitting up there, way up there. That's another situation where you go along on Nemo Road, and then you have to make this hairpin turn to get onto this private road and go up this road to this place, and someone's actually still trying to sell that place. You can see that road where just from precipitation, just the drainage and the ruts, not from anybody driving there or anything, but just simply from precipitation and creating ruts that's coming down this steep grade. So you wind up with, just off the top of my head, I can think of 3 unsellable lots that have been approved for developers, and they are not going to be sold, or if they are sold, the person buying them is kind of nuts, that create eyesores for our community. People lots of times are overdriving conditions on these roads. I mean, I don't know of anybody, frankly, who goes the speed limit. And you wind up with really, I think, serious safety issues on a road like this that people aren't necessarily going to know of until they are trying to get up that road, get their kids to the hospital, get, an ambulance up there, something along those lines. And they won't know this until they start to drive it, and it's just creating really extremely unsafe conditions, as well as eyesores for unsellable lots. Thanks.
Any questions for Lisa? Okay, thank you. Any other members of the audience like to speak on behalf of this item? Seeing none, currently there is a recommendation to approve subdivision regulation variance 1815 to waive the following planning requirements. We've had lots of discussion on this, and I'm also a big fan of safety and hearing what Rich had to say about the road and being the maximums of what did you call it, Rich, whenever you're talking about it? The
Design criteria.
the maximum design criteria that I'm at least in favor as a minimum as well as having guardrails. If you're gonna have that 15% road, I can tell you, on a 12% grade road in the hills on pavement hit a patch of ice that was in the shadows, and the guardrail saved me from going over the edge. That's just a personal incident where I hit a guardrail, and fortunately I didn't go over the edge. I wasn't speeding, but I hit a patch of ice and slid into it. So I tend to agree with you on that one. If we're going to go to the maximum on safety for the other one, I'm at least interested in a guardrail. Any other comments to that effect?
Well, I find that the applicant's argument that this is essentially a driveway to 8 houses. I mean, if they get the rezoning, it's a driveway to 8 houses. It's, if the rezoning does not get approved, it's a driveway to 4 houses. I think that, I mean, my driveway is not nearly as steep, well, it might be in one place as this. And you're right, there is erosion, there's patches of ice where the trees shade it. But it's our driveway, we deal with it, we know that it's there, and we're careful, and every few years, we have the guy down the way haul in more gravel and smooth it out again, and we have the guy down the way plow it when need be, and so this is just a driveway, and I think that the out of compliance issue, as the highway department pointed out, this is a local road, as they term it, and we really don't have requirements, except for that there is the 15% isn't cast in stone, it's a range, and the range can be up to 17. But the variance is really a little bit of distance, that they want a slightly greater distance of that 15% than the requirement is. So I find the argument quite compelling, and so I support the waivers as applied for.
Any other comments? And if not, I'd entertain a motion.
I'll move approval of the subdivision regulations variance 18-15.
Is there a second?
I'll second.
Motion and second. Any further discussion? Yes, no? I see some looks. I just didn't know. Any further discussion?
I think I need to say a substitute, but I need some help with that substitute. If, with this planning commission, Rich, I agree with you on the slopes and the guardrails and safety factors on here, but I need some help with number 3. And for me, me making the substitute, I guess I wasn't ready to vote on this, so if somebody else wants, I guess, okay, I'm just gonna try it. My substitute is a continuance, because I think on 19 and 20, they both need continuances, so you guys can look at them and not just guess what those things need to be. And that if Rich is right, that those need to have guardrails and just a closer look at this subdivision and what's going in there. So my motion, which I'm not supposed to talk on, is to continue till, what was the meeting, February the second meeting in February?
February 25th.
February 25th,
So you would offer a substitute motion
yes,
to continue this item to the February
25th meeting.
25th meeting.
I'll second that.
There is a second on that. Any further discussion? Being none, we'll go ahead and call a vote for that particular motion. All in favor of Deb Hadcock's motion, signify by saying aye.
Aye.
Aye. All opposed, no.
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 I believe that's 2 noes. I didn't see any others. So,
to 2.
okay. So then Deb Hadcock's motion passes. Now, do we resolve the first one, or does a substitute override the first motion?
Substitute overrides it.
Okay, just want to make sure. All right, that's item number 19. That takes us to item number 20.
All
I
right.
would, Cassie, if we could, I would like to continue that as well to the February 25th meeting as well. That would be my motion.
Second.
Motion and second. Any further discussion on that particular item?
Sorry, can we at least announce what number 20 is first?
Oh, sorry, PJ.
Can we at least let them give their staff report for that item? You don't want to do that? You just want to make sure, announce what it is? Okay.
Okay, so item 20 is rezone 1811 and comprehensive plan amendment 1810 to rezone 29.02 acres from general agriculture district to low-density residential district, and to amend the comprehensive plan to change the future land use from plan unit development sensitive to low-density residential district.
Okay, so that item has also been, there's a motion, and if I understand, a second to continue that item. However, I would stop for just a second, just in case there's individuals here that wanted to speak on behalf of that item that may not be able to. Do you see a problem with that, Deb?
No, that's up to this board, but usually on continuance, there's no discussion, but I would feel bad if somebody couldn't make it to the February 25th meeting, but.
Anybody have any problems with me at least opening up to the public to speak on that particular item? Since we did have one gentleman speak on it, a little out of turn, but it was necessary, I think. All right, any members of the audience like to speak on item 20 to give us some input or your perspective of it before moving forward? We'll take all your testimony that you've already given.
Commissioner, if any possibility to 60 days instead of the February or the March
Is there a reason why?
for attendance?
Deb, you made the motion.
I think delaying them on this would be not a good thing, meaning I think February 25th, they're trying to move forward, so February 25th to be fair to the applicants.
Certainly.
And you can call in.
Okay.
Okay, thank you,
Thank
sir.
you.
Any other input from this item? If not, current motion and second for continuance. All in favor, signify by saying aye.
Aye.
Aye. All opposed, no.
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 Motion carries with 2 noes. Item number 21. So we are here to discuss another date for our meeting. PJ, do you have anything to say before we get started?
Yep. Item 21 is a request for a motion from the Planning Commission to reschedule a special hearing or hearings to hear the Kroll Incorporated's application for mining and construction permits. Staff is recommending that the Planning Commission hold a meeting or meetings the week of March 4th. That way, the Board of Commissioners could schedule their meeting or meetings the week of March 11th.
Does anyone have any input for that week?
Mr. Chairman? I will not be available that week of March 4th.
Okay. Any other input? Is that week good for everyone? I know the 5th is not good for me. I will be gone on the 5th.
Also, unless you have it in the evening, that's a board meeting as well in the morning. And I believe that you also received a packet of emails that came in over the weekend requesting specific times for the meeting or meetings.
Yeah, I have various days within the month of March. So depending upon which day.
Oh, I'm bringing up my calendar. Well, does anyone have any suggested days or times to move forward with? for us to consider?
Previously, did we not have the calendar that showed when the presence of the attorneys, when
That-
they would be available?
That's in court, included in this March 4th request. Yep. So it's the earliest from when publication deadlines have to be met and also availability of those involved.
Okay, I just don't see it on the calendar, I'm sorry.
Oh, I see what you're saying from last time. Yeah. We know this week for March 4th and the week of March 11th, from the information that we got, they're available.
Thank you.
I'm not gonna be available then either, so.
That week, March 4th
Yeah.
week. So that would put 1, 2, 3, 4 of us plus a commissioner.
I'm not on the commission, so, I mean, I'm on the commission, just not that month.
In
So-
cases like that, we have requested an additional Board of Commissioner to attend. It'll be up to them whether they can or can't.
Whether they can or not.
If the Commissioner DeSanto is on in March as a regular attendant.
Knowing that we had 2 planning commissioners out, would it be more prudent for us to move into the week of the 11th? Well, the 11th is a regular planning meeting, so
That Tuesday, we don't have a board meeting, though.
no, you don't. Would it be prudent to move 12 and 13 of March? Schedule 2 dates on those.
Mr. Chairman, I'm available those days.
Mr. Chair, I'm available as well.
You're available. Sunny?
Available.
I'm
Sandy?
not available on any Tuesday.
What's the date?
I mean, any Tuesday after.
12th or 13th.
I am committed Tuesday afternoons in the month of March.
I'm not gonna be available until March 14th. Sorry.
I mean, must it be on a Tuesday? Could it be on a Wednesday or a Thursday?
Well, he's got marked the 13th and the 14th, but there's a Wednesday and a Thursday. Jim won't be available until the 14th, right?
14th, yeah.
Do we want to push a Thursday and a Friday, or is Friday off since it's not highlighted? Just out of curiosity.
The week of March 4th is desirable for the Planning Commission to hold the meeting, so the Board of Commissioners can hold it the week of the 11th.
We'll have to
The
push
dates that
ours
we were given
down.
were 4th through the 14th.
We'll have to push ours down then. Then we're gonna start in April going into equalization, so we
There-
wanna do
yeah.
whatever we do in March to start it, at least start the process.
And the availability of those involved does not necessarily mean they're going to be in town. They will be flying back from where they are.
Well, I'm open to suggestions. So if we don't do it on the 12th, we're out Sandy and Jim. If we did it on the 13th, we'd be out Jim, but then if we picked up on the 14th, Jim would be there, unless we moved it to the 14th and the 15th.
Or possible an evening meeting on the 11th. Then,
That won't be, not for me.
On the 11th?
No, I don't get home until evening of the 11th.
PJ, we need some help. Basically, the 14th is what they're saying, everybody can be here. Rich, Sonny, you guys are okay on the 14th?
So 3 o'clock on the 14th?
that'll be up to the Planning Commission. State's Attorney's Office and Planning Department would recommend the week of the 4th.
But you won't have a planning commission, so
We'll
obviously.
we'll have quorum.
Yeah, he says we can have a quorum.
Yeah, but myself, I wouldn't like 2 commissioners on when I'd rather have the planning commission. This is a good planning commission, guys.
We get a lot of
So,
good
a lot of
conversations.
questions, yes. And I think it's, I don't know, I wouldn't put 2 commissioners on there to take planning commissioners when we're gonna hear it again too, so.
All right. So we're looking at the 14th and the 15th of March. Does that seem at least?
That's your recommendation, that's where we're gonna have to go, guys.
All right, so those 2 days, so now what time on each of those days? Are we gonna follow similar as we did before, starting at 3 o'clock on the first meeting and then starting at 9 o'clock for the second meeting?
I'm good
Yes,
with
that makes sense.
I'm gonna encourage us to at least put a stopping time this time on the first meeting, so from 3 to 7. That way, if we get any documents or anything, we can at least go home, review all of that stuff before coming back. That way, we're not ending at 9 o'clock and then having to go home, review, and then come back sleepy-eyed and all that kind of good stuff. So I would say at least the first meeting, 3 to 7, 3 in the afternoon to 7 o'clock in the morning, 7 o'clock in the evening.
Wow, careful, Travis.
We could be.
I just want PJ to get here real early. That's what I want. And then, of course, starting the 15th, Friday the 15th at 9 o'clock.
Mr. Chair?
Mr. Chairman, were there going to be guidelines as to the length of time each person could speak?
Absolutely. And that's something that I'll go over with that morning or that afternoon when we start it up. We'll go over it for everyone. But standard thought process is about 3 minutes timed for individuals to speak. Individuals who sign up to speak can designate if they're going to yield time to someone else. So that's typically how we do it here, and you'll be able to sign up and yield their time. So, if PJ was going to speak for 15 minutes and there was enough people in the audience that signed up to speak and said I yield my time to PJ could spend 15 minutes to speak.
Yep, 5 people, yep.
So that way one person can give the entire brief instead of everybody trying to piece it off and then you're not trying to play that time game.
Mr. Chair, there's been some discussion of doing it like last time. Last time you scheduled the first meeting at 3, and then the second meeting was only if needed.
Correct. I still want to do it that same way.
Yes.
I don't want to guarantee a second meeting if we come to a decision after the first meeting, but I also don't want the first meeting to go as long if we end up deciding that we want to adjourn and consider any extra information that was given to us. So yes, the second meeting will be if necessary.
That's just
however it was worded.
It's what you guys did last time. So.
Right.
Okay.
Does anybody have a problem with that? All right. If so, I'd entertain a motion for those particular times and dates, and then a second.
I'll second.
I'll make the motion then, if that's the case. I mean, since we walked through it. Yeah. And then Sandy seconds it. So all in favor, signify by saying aye.
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 All opposed, no. Motion carries.
Thank you.
Takes us to item 22, County Board Report.
The Board of Commissioners concurred with the Planning Commission's recommendations from from December 17th, 2018 Planning Commission meeting.
Any questions about the board report? Nope.
Just kidding.
Go ahead.
I was teasing. You guys do a good job. A lot of times you see we concur. You thoroughly ask the questions. This has been, and I meant that, to be a really good board with all the questions and the things. You're hitting all the hard questions beforehand, and a lot of our commissioners are watching you before the meeting. So that tells you you're being very thorough, and we appreciate that. Thank you for serving.
Item number 23, items from the public. Is there anyone from the public? I don't see anyone. Item number 24, items from staff.
I guess now would be the best time to do this. I was just informed from Michelle that the applicant, so it might be possibly a reconsideration of the Kroll dates. The applicant cannot even be here on the 15th, which is why it wasn't given to us as one of the dates.
All right.
It's your decision.
What are the dates that the applicant can be here,
The
Michelle?
4th through the 14th, the ones that were desirable.
4th through the 14th?
Well, what about,
The 14th.
well,
Well, the 14th you've already decided at 9 a.m.
And how about before in February?
I mean, but
With
how
hearing,
about,
you can't,
I guess what that says to me, though, is that we need to continue looking out further, or doesn't that work because of your equalization and your,
I guess we'd have to make it work, but let's see what, Michelle, if this doesn't work for this board, then it's gonna be after the 15th then.
yeah.
The best I can say is leave the 2 dates, the 14th and the 15th. I would state, though, that this application has been pending since August, and due to no fault of the applicant, it's now continued into March, and it just so happens the attorney for the applicant is out of state and will be making a special trip back between the 4th and the 14th. The attorney's availability is limited to between the 4th and then the 14th. The best I can tell you then is if we leave it on the 14th and 15th, I'll inform legal counsel and
See if they can make it work.
and then, of course,
That's
that
pretty
begs the
close.
question of whether he can be here for subsequent board meetings. I think the point being that we were attempting to accommodate legal counsel schedules since the last, the continuances have been due to no fault of the applicant.
But you don't have a board is what we're saying for here, so we really don't have a option is what we're saying, if I'm correct. And that's what I've been
If we want to
listening to.
have the bulk of the board, if not all of the board, that was the concern.
Yeah.
So I guess the best I can say then is leave it the original dates as voted upon by the board, the 14th and 15th, and I'll just have to inform legal counsel.
I think it's far enough out that I think they should be able to accommodate that. Does that make sense? At least have representatives here that can be good. So,
Anything further?
Since there's a chance that that second day may not be needed, could we perhaps do 3 to 9 on the 14th, just make it a longer day? I guess we have no idea how much time we're gonna need, but maybe the 14th is all we need, we don't know.
well, if you can always continue it that night where you go, okay, we're almost done. Let's keep
Let's
going.
continue,
Does
yeah.
that make sense?
We
Sonny?
could.
You don't have to say 4 to 7 and then we're all gone.
Mr. Chair,
Unless there's a logistics issue.
there still hasn't been an official reconsideration of this item from the board, from the planning commission.
There hasn't,
What did you
I
say?
didn't hear that.
You guys are discussing, but you guys haven't officially
Well, they're
brought it
not-
up for reconsideration.
They're not asking for reconsideration yet though, PJ. So you said board and it was kind of your discussion as that meeting wouldn't work?
So maybe I should ask the question, are you suggesting that we, even though we've got an item 24 items from the staff, we need to at least say we want to reconsider and at least discuss this particular item that we've already voted on?
Well, I think Commissioner Hadcock actually has a good point. Brought it up during items from staff. There's usually discussion from the planning commission at that time, so I guess that'd be okay. If you are going to change something, though, you can't do it under items from
Correct.
staff.
Yes. If we change it, then you have to reconsider.
Reconsider.
Yes.
You know, my concern in putting an end time, and 7 doesn't concern me so much, but perhaps 9, is that I think then we're committed to stay until 9, because if somebody comes in at 8 o'clock or 8:45 and has a comment, they will, by
Yep.
posting it to being, the meeting will be from 3 to 9, we need to be here to take the comments. And so I personally am more comfortable with saying at 7. And then if you decide at 7 that, well, we've only got a handful here more, let's just keep going until we're ending, that I think is perfectly okay. It
That
doesn't
would be
have to
us deciding, not me.
That's right. Well, okay, but I mean, so I'm a little nervous about posting it till 9, for the fear that we'll just be sitting here until 9.
But yeah, we can definitely continue it, say we're going to, extend if we're going to try to meet the comments of everyone that's here, if it looks like there's just a few left.
All right.
So, Mr. Chair, am I correct that the path forward here is that we're going to be meeting the 14th and the 15th unless something comes back and it gets reconsidered at the next meeting?
That's the way I understand it at this point in time.
Thank you.
I surely hope that we can get through it on the 14th. That way we don't have to run into the issue on the 15th. However, if not, then we'll adjust or deal with it appropriately at that time.
Just a question. So on the 15th, PJ, I would say that you're going to have it at, you said 3 o'clock, and then you said the 15th. If needed, you were going to have that meeting. You should post that meeting's not going to be at 3 o'clock. Again, it's going to be at 9 or 2 or whatever. So
Yeah,
Right.
9 o'clock.
9
that's what
o'clock.
I'm saying. So that's, the public knows if we have the meeting next day, it's not 3 o'clock, it's 9 o'clock.
Correct.
Just make sure that's posted right, yeah. Thank you.
All right.
Other
PJ,
items?
other items.
Other items, the building permit report for 2018 December. Single-family homes were down 15% over this time last year. Well, they were up in December, but overall for the year to date, there were 87 single-family homes in 2017, and we took in and issued 74, so down 15%. Again, cell tower additions and technology changes, that's up almost 60% over this time last year. Garages and carports, that's up 9%. Residential additions, which are things like finishing a basement, adding on a porch or a deck, That's down 22%, and so are non-residential additions. Three items that make up 13% of the overall applications that we took in were actually removals. So removal of residential buildings, non-residential buildings, and mobile homes. So out of the 785 building permits we took in, were issued last year, 104 of those were for removal of items. So those are pretty high numbers. Overall, for 2017, the number of building permits we took in was up at 11%. The valuation of those building permits was down 11%.
Any questions? All right, next item.
Yep, and just a reminder that the hearing of the comprehensive plan will be the next planning commission meeting, January 28th. It's not the only item on the agenda. It will be the last item on the agenda.
Thank you very much.
Gary will be filling in for me on January 28th. PJ, just so
Gary?
you know.
Okay.
Yeah.
Okay, one more item, sir.
I'm welcome to what?
One more item, sir.
One more item?
Yep.
Okay.
Do you want to do this, or it doesn't matter? Thank you.
We just wanted to introduce you guys to our new ordinance enforcement officer. This is Amanda Lopez. She spent, well, I'll let you give a little history on yourself. We're very excited to have her, though.
Thank you. Good morning. Like Cassie said, I'm Amanda Lopez, and I wish I had some compelling introduction to give you, but I had no idea that I was getting up here until just now. But what's that? Oh, yes, best way to do it. So I'm in my third week with this department. Previously, I was with the Pennington County Sheriff's Office as a deputy sheriff and investigator. So it's been good to get back out in the community and get reacclimated with the geography and the citizens, and it's been interesting. So nice to meet you all. Welcome.
Well, welcome.
Thank you.
Yes, welcome.
All right, items from the membership. Anyone have anything pressing?
I just have a comment, regarding our meeting and the cancellations of the meetings. I'm just hearing two conflicting reports. One report said that the meeting was canceled because of failure to post the 24-hour notice. However, the general public in Copper Oak subdivision have been contacting me saying that the reason it was canceled was because PJ couldn't count 30 days from the date that it was publicized. And so I know, I hear all kinds of things.
So do we.
See, I understand that. I have been adamant in my response, saying, no, it was a simple error in not
It was a simple
physically
error.
posting it. Putting the piece of paper in the slot is my understanding. So if you could just clarify that for me.
Yep. There's an outside bulletin board, and to keep in accordance with South Dakota codified law, I can't remember the exact number right now. I think it's 125, 1.1 maybe.
It doesn't
has to be
matter.
viewable 24 continuous hours, and that's what the outside bulletin board does. It is put on the website, but the staff member responsible for it didn't post it on the bulletin board. We didn't find out until that morning.
Does that answer your question?
So if
And if
Yes.
there people are watching, they'll at least get the answer straight from us here. And
if the meeting was held, it would have been in violation and some misdemeanor.
Yeah, I understand. I just, like I say, I heard so many people tell me the other story that I thought I would just hear it once again from the horse's mouth.
Nothing new.
Thank you.
all right, anything else from members on the board here? Seeing none, I'd entertain a motion to adjourn.
Yes, let's
Move to adjourn.
Move to adjourn from Rich. Who seconded? Was that Deb? All right.
Sound like Rich?
No, he said motion. All in favor signify by saying aye.
Aye.
Aye. All opposed, no. We are adjourned. Thank you.
Thank you.